We have well over 200 people in the room already. So welcome everybody to the annual debate of the Africa Arbitration Academy. This is for 2021 and it's titled The Battle of the Titans. We'll come to the debate, the topic of the debate. And my name is Emilia. Onyema. I'm a professor of international commercial law here at SOAS, University of London. We have two titans of the international arbitration community with us for this debate. I'm going to introduce them. I would then invite Abayomi to say a few words on the Africa Arbitration Academy. We'll go into the debate. So get your pencils and your pens and your papers ready. And we will come back. We'll have a right of reply, of course. Please, if you have any questions, put them in the chat and we'll try and take as many of those as we possibly can. The session is being recorded. And so we presume we have your consent for the recording. It's also being live streamed. So you're quite lucky to actually be on the Zoom version of this. So to quickly introduce our two titans, they do not require introduction. But I'm going to say a few words on both of our two senior colleagues. They're both professors. They are well known within the international arbitration community. They have published, they're thought leaders. They have received several awards, both of them. But wait for this. Between both of them, they have acted as counsel, as sole arbitrator, as co-arbitrator, as presiding arbitrator in ad hoc, various institutions. They've been appointed by the parties. They've been appointed by the institutions in almost 1,400 international arbitrations. That is huge. Now you know why we say Battle of the Titans. And so it is important. And we recognize the work they do within our community, for which we are really, really grateful. So we're very, very grateful that we have both of them fighting it out now today. But before we start, I think we do need to recognize that we've also lost some of our colleagues and some of other titans within the international arbitration community. We would like to invite you for us to take a minute silence to remember Emmanuel Gaia, Professor Emmanuel Gaia, and Professor Martin Hunter that we lost late last week. Thank you very much for that. Now I'm going to invite Abayomi to please say a few words.
Thank you very much, Emilia. Ladies and gentlemen, it is with great pleasure that I welcome you to the annual Africa Arbitration Academy debate themed Battle of the Titans. And just as a form of background about the academy was established due to the rising demand for improved expertise and training of arbitration practitioners in Africa, and to expose practitioners within the continent to the current trends and developments in international commercial and investment arbitration. Now, the overall objective of the academy is to provide the much needed specialized training to arbitration practitioners from Africa and to equip them with the right set of skills to succeed within the international arbitration community. And since inception in 2019, the Academy's flagship training program has featured more than 17 young practitioners from 35 African countries. And the Academy continues to receive immense support from major law firms and institutions from around the world. And apart from the flagship training program, the Academy has also been at the forefront of development of interest to Africa and is always keen to lead the way to innovation and develop the practice of international arbitration in Africa. Last year, and some of us may be aware of this, during the pandemic, the Academy launched the Protocol on Virtual Hearings, which considered the specific challenges and circumstances that may arise in relation to virtual hearings in Africa, and was uniquely designed around some of the specific issues relating to access to technology and infrastructure within the continent. The protocol won a number of awards and has been adopted by several arbitral institutions in Africa. Apart from the flagship program, the Academy has also launched other value-laden initiatives, including the survey on cost and dispute funding in Africa, and the recent initiative with Exceed, the executive legal training on investment arbitration for general counsel and government reps in Africa, which of course we are working with Exceed and World Bank on that. Here today, we are here to watch the Titans, watch them debate. This is the high point of the flagship training program, and it is a real privilege to have two of the world's preeminent arbitration practitioners join us. I recall during our internal discussions on selection of the debaters, Professor Gary Bond and Professor Jan Paulsson's name were on everyone's lips. And this was particularly the case, not only because both debaters are highly revered arbitrators, but also because of the great contributions that they have made to the world of international arbitration through their writings. Gary's leading text on arbitration and Jan's masterpiece, Idea of Arbitration, provided unquantifiable guidance to me, in particular, in my PhD thesis. From me to you, thanks to both of you for that. The topic for today, party-nominated co-arbitrators, is one of the topics that continue to be fiercely debated and remains topical within the arbitration community. And I won't say anything further on this, as I don't want to be caught in the line of fire. I will yield the floor to Emilia, our able moderator, to get the ball rolling. But I urge you all to follow the debates, participate by asking questions. You can put your questions in the Q&A box and be part of what promises to be an enriching session. Thank you all.
Thank you so very much, Abayomi. So the next thing for us to do is we want to gauge your own temperature, where you stand on this debate. And so I'm going to invite Abayomi to please present the poll. So can you please vote now, including our debaters? They need 1 point each. Oh, we can't, panelists can't vote. Sorry, Gary and Ian, you can't vote, but that's okay. I think Abayomi, are we done now? Can we see the results?
No, we are not done.
Not done yet. Okay. Please vote, don't overthink this. Go on, just vote. You'd get another opportunity to vote. Abayomi, are we ready?
Okay.
So we have 88% said yes, we should continue to have party-nominated co-arbitrators. 13% said no, somebody has a lot of work to do. Okay, great. So we will start our debate now. I'm going to invite Gary to please make submissions in favor of the motion. Gary has 15 minutes to make his strenuous submissions, and then Jan would respond. Gary, please.
Thank you so much, Emilia, and thanks also in particular to the African Arbitration Academy, and especially to all of those all around Africa, all around the world who are taking their time to watch us today. We appreciate the opportunity to address you on this very important issue very much. It is, the topic of today's debate is truly important. It's foundational. It is, I would submit, critical to the health and the future of international arbitration. The practice of party-appointed arbitrators is, as I hope to describe in the coming moments, ancient in its historical origins. ubiquitous in its contemporary practice, both in national law, arbitral institutional rules, and customary practice, commercial practice among parties and among countries. It has enjoyed that status, the status of being a fundamental aspect of international arbitration, international adjudication for 20 centuries or so, because it makes perfect sense. Before I address why the practice of party-nominated arbitrators makes sense, though, let me underscore what a threat rejecting this motion would pose to the very foundation of international commercial and international investment arbitration. The motion here before us today is to permit continuation of the time-honored practice of party-nominated arbitrators. To take that right, the right to appoint, to nominate and appoint co-arbitrators away from the parties would be to strike at the very foundation of international arbitration. As we know, as we learn in International Arbitration 101, consent is the foundation of international arbitration. Parties choose to resolve their disputes by arbitration, and in doing that, they choose to resolve their disputes in particular ways according to particular procedures. Those rights, the rights of procedural autonomy, party autonomy, are enshrined in the New York Convention in Article 2, 2.1, and 2.3. And the right of the parties to constitute the arbitral tribunal in the way that they think best is further confirmed by Article 5.1d of the Convention, which permits non-recognition of awards if the parties' agreed procedures for selecting the arbitrators haven't been followed. Where parties agree, as we will see they so often do, to arbitrations conducted by tribunals which they appoint, including by appointing co-arbitrators, to take that right away from them would be to strike at the very basis, the very legitimacy of international arbitration. It would not just violate the New York Convention, but it would violate the very reason that we have international arbitration in the first place, to allow parties to resolve their disputes in a mechanism of their choosing. Let's turn from that fundamental proposition, which in a sense is the end of the debate, parties' freedom to select party-nominated arbitrators as their means of resolving the dispute, should be the end of discussion. We don't sit here as some super legislature imposing dispute resolution mechanisms on parties. Rather, arbitration is all about permitting parties to decide how they will resolve their disputes. And we ought not presume, we ought not have the arrogance to impose upon them other means of dispute resolution, which we think might be better for them. But let's look at how ubiquitous, how uniform throughout history this practice of party-nominated arbitrators has been. It goes back to the first recorded uses of arbitration. The ancient Greeks used arbitration to resolve both state-to-state and commercial disputes, invariably with 3 or 5 person tribunals, with 1 or 2 of the arbitrators, depending on the size of the tribunal, appointed by each of the respective disputants, and those co-arbitrators seeking to agree upon a presiding arbitrator. The Romans did the same thing, except with almost always 3 arbitrators in commercial cases. Throughout the Middle Ages, in the trade fairs and elsewhere, the same practice was used. Co-arbitrators selected by the parties. Gerard Malines, a classic writer on Lex Mercatoria in the 17th century in England, described how arbitration was used with 3 person tribunals, one party nominating one co-arbitrator, the other party the second. Likewise, in state-to-state arbitration, throughout recorded history, states chose to select tribunals, which they participated in constituting by selecting co-arbitrators. A treaty in 1254 among the German states provided for resolution of disputes, state-to-state disputes among the German principalities by a tribunal in which the disputing states themselves selected co-arbitrators. A treaty between Switzerland and France in the 13th century did precisely the same thing. And a proposal for interstate arbitration by Pierre Dubois in 1306 did precisely the same thing, providing for a 9-person tribunal, each of the 2 states involved selecting 3 co-arbitrators. Throughout recorded history, indeed, just in the last centuries with Jay's treaties, the Alabama arbitration, the Abayomi arbitration here in Africa, the Eritrea-Yemen dispute, state-to-state arbitration involving an African state, the Ethiopia-Eritrea disputes. In every one of those cases, the states involved chose to design a mechanism that involved party-nominated co-arbitrators. It's not just that history recognized the freedom of parties to select co-arbitrators, but it emphatically embraced it because it gave the parties confidence in the process. One doesn't need only to look to history, to historical examples over the past 20 centuries or so of how co-arbitrators were fundamental to the very fabric of international arbitration. We can also look at contemporary affairs. We can look at contemporary preferences of parties. One example, of course, is the poll that we just conducted, in which 88% of you quite rightly affirmed the desirability of party-nominated arbitrators as part of the arbitral process. But you should take comfort that you are by no means alone. Indeed, with almost eerie precision, the outcome of your poll is just what the outcome of a 2012 Queen Mary University poll of international arbitration practitioners around the world was. 83% of arbitration practitioners in that poll preferred party-nominated arbitrators to any other means of dispute resolution. In-house counsel were at 73%, and the only people who sort of dipped down in their approach towards party-nominated arbitrators were, oddly, arbitrators. Only about 60% of them favored party-appointed arbitrators. One wonders if there wasn't a touch of self-interest in that particular poll result. The results that one saw from the Queen Mary study were almost identical as well to a study that Professor Buring-Uhle did, in which the most important criteria that led parties, commercial parties, to favor international arbitration was their ability to select the co-arbitrators in the case for themselves. That contemporary practice is reflected as well, as I'm sure you all know, in the drafting of actual commercial arbitration agreements, not academic theory about what the best dispute resolution mechanism might be, but pragmatic commercial decisions by business people, men and women around the world, who, when they draft their arbitration clauses, include provisions for each party to select its own co-arbitrator. And that reflects a fundamental characteristic of the arbitral process, just as it did historically. It's not just commercial practice that approves of the use of party-nominated co-arbitrators. It's also every bit of national legislation in the world today. The UNCITRAL model law in Article 11 not just permits party-nominated co-arbitrators, but provides it as a default solution if the parties haven't otherwise agreed on how to constitute the arbitral tribunal. 100 jurisdictions around the world have adopted Article 11 of the UNCITRAL model law, reflecting not just the views of commercial parties, which we've seen, but also the views of legislatures in every part of the globe, including in Africa, I might add, where the Kenyan, the Nigerian, the Rwandan versions of the model law all adopt Article 11, and where in Tanzania, Morocco, and elsewhere in the continent, legislatures have provided exactly the same default solution. Note here that legislatures don't just approve the practice of party-nominated arbitrators and reject the notion that somebody should impose upon the parties some different mechanism of selecting the arbitrators, but prescribe it affirmatively as the default solution if the parties haven't agreed. No state does anything different. Arbitral institutions, which know a fair bit as well about how to constitute and select arbitral tribunals, have followed almost uniformly around the world. The UNCITRAL arbitration rules in Article 7, the ICC rules, the SIAC rules, the Deutsche Institution für Schiedsgerichtsbarkeit, every leading arbitral institution, including in Africa, the rules of the Mauritius, the Ethiopian, the Nigerian Lagos Center, the Cairo Regional Center, all of these arbitral institutions, again, provide not just for the parties' ability, if they've so agreed, to use party-nominated co-arbitrators, but provided as a default solution in the event that they have not. And again, this almost uniform, long-standing recognition and use of the practice of party-nominated arbitrators reflects the importance of this mechanism to international arbitration itself. There are good reasons that throughout recorded history, states, commercial parties, arbitral institutions, and private lawyers have affirmed the use of party-nominated co-arbitrators. Those reasons are that parties, particularly in international matters, where there are differences in language, differences in culture, differences in legal regimes, differences in perspective, want direct involvement in the constitution of the arbitral tribunal, particularly through the ability to nominate mutually, along with the opposing party, one member of the arbitral tribunal. This provides the time-honored means of ensuring that the arbitral tribunal consists of members who are familiar with the issues in the party's case, who are familiar with the backgrounds from which they come, and importantly, who will have adequate attention and motivation to attend to the resolution of the party's dispute. At the end of the day, disputes are between parties. Those parties know better than anyone in the world what their dispute concerns, and they have greater incentives than anyone in the world to properly and appropriately select members of the tribunal who can address in expert fashion how that dispute should be resolved. The notion that, and I can speak from experience here as the former head of a leading arbitral institution responsible for selecting arbitrators when the parties couldn't agree. The notion that an arbitral institution can do a better job than the parties in choosing who ought to resolve their dispute is supreme arrogance. Parties know better. That's why their choice of arbitration is respected. That's why their choice of arbitral procedures is respected. It's why it's been done throughout history and continues to be the case today. To take that right away from them, to impose on them some other solution for how to resolve their disputes is the surest way to drive parties away from arbitration and back to national courts, where exactly the proposition supported by the opponents of the motion would put us. Thank you very much for your attention. I hope that when we're done with this, we won't be at 88, but 98. Thank you again.
Thank you very, very much, Gary. I'm going to invite Ian to make his counter submissions.
Thank you very much, and thank you for inviting me to this debate. Anything to do with Africa is something which I, with great sentimentality, tend to accept. I had the most wonderful childhood that any human being could have. It was in Liberia. My first driver's license is from Liberia. I still have it. I drove a Willys Jeep up in the jungles. Not in Liberia, not in Monrovia, 300 kilometers up in the jungle. If anybody knows the geography, it's a little area which is a triangle between Colahun and Liberia, Nazarikori and Guinea, and Kailahun in Sierra Leone. and that's where I spent my childhood. So Africa to me is a place where I often think about those idyllic days. I won't keep you in suspense. I'll explain to you how I'm going to win this debate very easily. As the ex-president of the United States might say, I might lose the vote, but I will win the debate. And I'll explain to you how that is done. Two ways. First of all, I will cheat. And secondly, well, you'll see how I go along. And the reason I have to cheat is because the debate, I have to cheat back. I have spent quite a lot of time thinking about the limitations that I believe we should consider as appropriate to the use of unilaterally appointed arbitrators. And whenever I'm asked to speak on this subject in various places, invariably the question is biased against me in a way which precludes making any meaningful progress. As exemplified by the poll which Gary Bourne just mentioned, not the poll you just did, the outcome of which is inevitable. I would have voted yes, but the one at Queen Mary's. Okay, how would you think? How would you feel about somebody taking away a right that you have and arrogantly telling you what you must do and removing your freedom? I've been introduced that way. Mr. Paulsson has now addressed us, and he is in favor of taking away the right to appoint arbitrators. It's not a very promising thing that you want to defend. And let me just correct that. Let's get our terminology right. To speak of party-appointed arbitrators leads to confusion. It's a bit inexact. You can never have an arbitration unless parties have agreed to it. So in that sense, in every form of arbitration, there are arbitrators who have been appointed in accordance with the agreement of the parties. If arbitrators are purporting to act as arbitrators and who have not been appointed in accordance with the agreement of the parties, that arbitration is a nullity. So every arbitration has party-appointed arbitrators. This is a useless expression. Unilateral arbitrators is what we're thinking about, and I am inviting you to consider the limits that would be healthy for the use of unilateral arbitrators. I don't want to interdict anything. I don't want to prohibit anything. If you want to have an arbitration system where you can appoint your grandmother, who, if she is anything like mine, thinks you are the most good-looking, intelligent, and honest person who ever walked in the world and will never accept that you are wrong, well, do that. But I'm not sure that we should call my grandmother an arbitrator in a case where I'm a party. It's sort of stretching it too far. But if that's what you want to do, go right ahead. But let's not think that this is the right way to have arbitration. I've been sad the last couple of days since hearing of the death of Martin Hunter, but he was such a man full of life and humor that I prefer to think of him in all of the joy that he had in practice. And we're thinking of him not my personal loss, but the lawyer, Martin Hunter. And he was whimsical, he was mischievous, he was iconoclastic, he liked to change people's minds if he thought that they were thinking in patterns that they hadn't thought out. And he said very many clever things. One of the things that he is most remembered for, he probably regrets that he had said because it's been misconstrued so much. And it makes him, he thinks, sound like something of a rascal or a crook. This is what he writes. These are famous words, and some of you have seen them many times. When I'm acting on behalf of a client, he wrote, what I'm looking for when I name an arbitrator is a person who, and now I'm quoting, has, I'm quoting, the maximum predisposition toward my client, but with a minimum appearance of bias. You can see how that could be taken to be very cynical. I think what he meant was the maximum favorable predisposition toward my client, because predisposition can be negative and positive. But anyway, that's how he said it, and this is what he meant. Now, he probably would like to have reworded that. It's been quoted hundreds and hundreds of times, because of course this could be used in the wrong way. The good way is this: when you're representing a client, you want to win, and everything you do as representing a client is aimed toward winning the case. And therefore, you have a duty to do that in every step of the process, including the nomination of an arbitrator. But Martin Hunter wasn't proposing crookedness. He wasn't proposing that you should pay somebody to vote for you as an arbitrator. He wasn't proposing that you should look out for the person you know always is in favor of the party that appointed him or her. He was rather suggesting to people what they should do is to be intelligent lawyers. And you analyze the case you have, and according to the type of a case you have, inform yourself about the people who might possibly serve as arbitrator, and choose among those people those whose intellectual predispositions lead themselves to favor the kind of a thesis you have in your case. It's a very, very different thing. And obviously you can stray at some point to an area where this becomes uncomfortable if the question is too precise. But you know what I'm talking about. Some people are really long on equity and others are long on textual decisions. And sometimes you want one and sometimes you want the other. And if you don't reflect on this, you're not doing a service to your client. So that is why I prefer to use the word unilaterally appointed arbitrator. And I think there are great dangers with unilateral arbitrators. I don't think they should be forbidden. So I'm cheating. I'm changing the question a bit. So I might lose the vote, but I'll win the debate anyway. I think in every situation of drafting a contract clause, you should consider whether you want from the get-go to have unilaterally appointed arbitrators. How did I start thinking about this? It actually happened to me, as many things do in life. You discover it just by going about your business. For a few years, I had responsibilities as an officer of the London Court of International Arbitration. And I used to walk the corridors there and say hello to the staff members who were working on cases in that institution. And one day, I noticed two of them. People who work in arbitral institutions tend to be very enthusiastic about arbitration, very intent on giving good service to the parties, and competitive. They want their institution to be the best in the world, and there's nothing wrong with that. It's very healthy, and they're very proud of what they do, and they're very devoted. So I saw two young staff members of the LCA walking down the corridor and saying things, oh, did you read the award in such a case? And it was such a great award, and wasn't that nice? And so I interrupted them. I said, please tell me what you're talking about. I want to know what you think is a good award. I thought this was a very interesting thing to find out why they were staff members of an arbitral institution were actually commenting and being very enthused by an award which they had seen. Think about it. If you were a member of an arbitral institution, what would you like about an award? It turned out that the answer is threefold. You wouldn't be able to guess this, but when I say it, you will understand in a nanosecond. Number one, it was rendered on time. Staff members at an institution like that, when an award hasn't been rendered on time, who do the lawyers call and complain to? The arbitrators? No, you don't dare to do that. They're going to decide your case. You call the institution and get a hold of somebody on the staff and give them a hard time. So on time is good. Number two, the arbitrators didn't ask for more money. The deposit that was given at the outset of the case was enough. Staff members like that. Who do parties complain to when the arbitrators ask for more money? To the arbitrators? No, they're going to decide your case. You don't want to offend them. They call the institution and start giving the staff members who have nothing to do with this, start giving them a hard time saying, how come these arbitrators already have used up our funds? And what are they doing anyway? Why haven't they finished it? Number three, the most important. The award makes sense. It was given on time and it makes sense. Now that's perhaps a little not so obvious to explain, but I said, what do you mean? It makes sense. Well, it's very clear and it doesn't hem and haw and you understand the decision and it doesn't confuse you. Thought, well, okay, that's interesting, and more on that in a bit. And then I asked them, what case was that, by the way? Tell me. And they told me the name of the parties. And I had a sudden idea. Said, isn't that one of the cases where the default rule of the LCIA applies? And they said, yeah, how did you know? I said, I didn't know, I was just wondering. What's the default rule of the LCIA? What was the default rule of the LCIA? If the parties agree to LCIA arbitration, it will be a sole arbitrator. Unless they agree otherwise. If they have agreed on 3 arbitrators, the 3 arbitrators will be appointed by the LCIA. That's the default rule. Unless they have decided otherwise. Always unless they have agreed otherwise. Freedom. Do what you want, okay? So this put me on a mission of checking all the cases where the 3 arbitrators were appointed by the institution and the other ones, and to see how often these 3 good things about arbitral awards from the standpoint of the institutional staff were met. And you won't be surprised to hear what I have to say, is that the good arbitrations tended to be the ones where the 3 arbitrators were appointed by staff. What happened in the other ones? What tended to happen in the other ones is that there was an arbitrator who didn't agree with the others. That takes time. That's what takes time. And is very adamant about not agreeing. Not sort of like a friendly disagreement and I'll put down that I disagree and we can go on. No, 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 I insist. We have to talk about this more. So that takes more time. It costs more money because the arbitrators are spending time on it. And guess what? I get back to this. You get an arbitral award, which you sort of on the one hand, on the other hand, and there's confusion and who is right and who's wrong, and do I really agree with the majority or not? And it sort of frays at the edges of the legitimacy of the process. So it started me thinking, and that's how I developed my position, which is a more moderate one than you would guess from the way this debate has been styled, because this idea of preventing people from doing what they want is very foreign to me. Consider in every case that the LCIA default rule is a very good one until the arbitration has started. And at that moment, remember what the rules say, unless the parties agree otherwise. You as the lawyer for the claimant, or either party, you as the lawyer of a party can call your colleague on the other side and say, have you read this ridiculous default rule that we have in our contract? I'm suggesting put it in your contract. It doesn't have to be LCA, or if you have an LCA clause. Yeah, it says that the institution will appoint the 3 arbitrators. This is terrible. When in history was that ever a rule? And they can repeat everything you just heard from Professor Bourne. So let's agree that you appoint one and I appoint one, and we then try to appoint the presiding arbitrator together. Wonderful. I'm all in favor of it. What's the beauty of it? In the case when the person opposite you is a person you don't trust, is a respondent who is dead set on defeating the claim at any cost, including every conceivable way of sabotaging the arbitration, naming arbitrators who will resign at critical moments and you have to start over again, naming arbitrators who will defend the point of view of that party, whatever happens. You don't want that. It can cause life to be impossible for a claimant. You will never get a decision, and when you do, it will have all these bad things about it. So it's a modest proposal when you think about it, what I'm suggesting. Give some thought to the fact you can always agree otherwise. Then you say, but maybe we won't agree otherwise. To which I say, why aren't you agreeing otherwise? The reason you won't agree otherwise is that I'm right. You are in a case where you prefer that the 3 arbitrators are named by the institution. Hence, the debate about the unilaterally appointed arbitrator is not as simple-minded as you think. It is not a matter of what is forbidden and what is allowed. It's about thinking about the process in an intelligent way and creating incentives for the appointment of good people from the beginning on both sides, and having a control on that by there being this little wrinkle, which, by the way, in my 7 years working at the LCIA, I can tell you that maybe we should have a vote of this, but I'll tell you the result. Since I became very interested in this, I followed it. In the cases where the parties had not put in their clause that each side will name an arbitrator, but just said, we want LCIA arbitration with 3 arbitrators. And very often they don't realize that the default rule is this wonderful default rule. And they see it and they think it's terrible. See? They can call their friend on the other side or their adversary on the other side and agree otherwise. At that moment, why not? How often do you think that happens? Most of the time. Wonderful. Nothing is wrong with the system. It's a good system. The default rule is there as a bit of a disincentive to naughty behavior. And if the parties are not being naughty, then they can go back to this idea of each side appoint an arbitrator in whom they have trust. And they will do what Martin Hunter said, not because they're crooked, not because they appoint corrupt arbitrators, not because they appoint arbitrators who will vote for them every time, but arbitrators whom they trust because they think that their philosophy of resolving dispute is in accordance with the sort of things that they will be arguing in the case. And that is all to the good. And please think about it. Thank you very much.
Thank you very, very much, Ian. Gary, it looks like from the chatter in the chat that you're losing some faithfuls. So 5 minutes, you need to win back your people.
That's hard to imagine, given that Professor Paulsson has so graciously conceded both in what he said and what he didn't say. Let me try and be a graceful winner, taking note of his quite accurate observation that this wasn't a vote that he could win, and his efforts to redefine what the motion is before us today. The motion is party-appointed arbitrators, yes or no. Can we permit them or can't we permit them? That's why Professor Paulsson said he needed to cheat by redefining the motion in a very different way, which is, yes, of course, we permit party-appointed arbitrators, what he calls unilaterally appointed arbitrators, but we have a default rule that would impose a different solution if they haven't expressly agreed on party-appointed arbitrators. That's not the motion before the House. And therefore, with respect to the motion that we do have to decide, are party-appointed arbitrators permitted, yes or no? The vote, I think, quite clearly must be, as Professor Paulsson and his grandma would agree, in favor of the motion. Let's look more specifically, though, at what Professor Paulsson didn't say, and then some of the things that he did say. Professor Paulsson, you'll note, didn't address any of the historical uses of 20 centuries of unilaterally appointed co-arbitrators. He didn't address any of the legislative instruments all around the world, particularly in Africa, but also elsewhere, that affirm precisely the same mechanism. Importantly, not just giving parties the freedom to use unilaterally selected arbitrators, but applying it as a default solution, the opposite of the default solution that he would prefer. He didn't address the institutional rules in every institution in Africa and elsewhere, applying as a default mechanism that which the United Nations in the UNCITRAL arbitration rules prescribes, namely party appointed, in his words, unilaterally appointed co-arbitrators. All of this reflects accumulated wisdom, pragmatic learning, practical desires of commercial parties over decades, indeed over centuries, as to the desirability of party-appointed co-arbitrators. There is, of course, one institution, the one that Professor Paulsson headed, the LCIA, which has a different default solution. It too doesn't vote in favor, if I can put it that way, of the motion, because it permits parties to agree upon party-nominated arbitrators. And I think perhaps the most important thing that Professor Paulsson said was towards the end of his comments. In some cases, parties don't explicitly provide in their arbitration agreement, as a number of arbitration agreements, most arbitration agreements do say, that each party can select a party-nominated co-arbitrator. And in those circumstances, as he described, the LCIA's idiosyncratic unusual default rule kicks in, providing that the institution, the LCIA, would select the entire tribunal. And what happens in those cases? He told you. What happens in those cases, in the vast majority of those cases, is parties choose, even after a dispute has arisen, when they probably can't agree on anything, they choose the mechanism of party-nominated co-arbitrators. I think that speaks volumes about what parties actually want. And so why in the world should we take that right, that practice away from them? And why should we impose a different default solution? I don't have time to address all the problems with Professor Paulsson's pretended solution, namely institutional appointment of arbitrators, but let me try to address some. Institutional appointments are no panacea. I've headed an institution. I've had to make appointments. I can tell you, institutional appointments lack the immediacy, lack the intelligence, lack the nuance of party appointments and party agreements on presiding arbitrators. Institutions choose by committee off lists that tend to be stale, often male, and usually pretty pale. None of that makes much sense for arbitration in today's day and age. What makes much more sense is the parties' freedom, their ability to select arbitrators, aware of their cultural, their linguistic, their legal backgrounds. The selection of institutional lists is fraught with grave dangers of cronyism, politicization of the sort that you see that attends the selection of judges on the International Court of Justice, the confirmation hearings for court processes that you see in some jurisdictions. Parties agree to arbitrate precisely to escape from those kinds of cronyism and politicization events that occur in national courts and international tribunals. Much better is a mechanism of party-appointed arbitrators where, importantly, the co-arbitrators very frequently are able to agree upon the presiding arbitrator. Thus, the parties have been directly involved in selecting the entire tribunal. Professor Paulsson speaks briefly about the risks of dissents if you have party-nominated co-arbitrators. It is absolutely true that party-appointed arbitrators often bring an attention, a diligence, a rigor to their mandates looking carefully at the parties' positions, bringing up inconvenient facts or awkward legal authorities that might make what looked like an easy decision a little bit harder. It sometimes leads to results that are not black and white, that don't result in one party winning everything. That, though, is a good thing. That is precisely why parties agree to arbitrate, because they want the nuance, the sophistication that comes from a three-person tribunal. That's why the UNCITRAL model law and most institutional rules have, unlike the LCIA, a three-person tribunal as a default mechanism, precisely to get the nuance that is so important in international matters. It takes into account each of the parties' respective backgrounds. Institutional appointments also, of course, raise the question of which institution. And no doubt some of those in Europe or North America would readily assume that it would be a European institution, letting a European institution or a North American institution select all of the arbitrators, regardless of the nationalities of the parties. Might be convenient for some, but it is not a satisfactory solution in today's era, with parties from all over the world, Africa and elsewhere, involved in disputes. There, the true way to respect the parties, their autonomy, their backgrounds, is to allow them, as parties have for centuries, to select their own co-arbitrators. And I think with that, hopefully I've gotten Professor Paulsson's grandma's vote, as well as yours. I look forward to seeing the final poll. Thank you again, Emilia.
Thank you very, very much, Jan. Gary, can I turn to Jan for your last 5 minutes?
Yes, well, of course, as you know, if forced to vote in accordance with the wording, I vote yes. But this is not the debate I'm having. The last thing I would have said if I were arguing the opposing position is to start talking about dissenting opinions. Dissenting opinions have been calculated on a number of occasions, most often at the ICC, where people have had access to the files and counted up the number of dissenting opinions in a given year. So you would like to know in what percentage of the cases was the dissenting opinion written by the arbitrator who is appointed by the losing party. And you might be a cynical person and you would guess that it's more than 90%. Well, no, it's 98, and in some cases 99.5. There was only 1 year, there was only one case where somebody other than the arbitrator appointed by the losing party issued the dissenting opinion. So this is not, when you say, oh, the dissenting opinions are great because it shows that the arbitrators really thought about it. Well, then why isn't the dissenting opinion coming from the presiding arbitrator? So this is suggests that party-appointed, unilaterally appointed arbitrators are sometimes appointed in an abusive fashion and are appointed by parties who know that they have somebody who's going to be in their corner, which doesn't help very much if it's in the minority, but it suggests something which isn't terribly healthy. Obviously, well, we have to rely on the presiding arbitrator being appointed in the proper way, and that is a challenge. And if the parties can agree, well, so much the better, and they have to live with the consequences of their choice, or they can't complain. Often they cannot agree, and the institution has to appoint. And it is entirely true that this is a challenge. Not all appointments are great. Institutional appointments are what they are, but that will be the person who decides if it's going to be 2 to 1. And so we have to see to it that institutions continually reform. But that's a different subject. And I could go on for an hour talking about the challenges of transparency, the fight against clientelism, and the fight against capture by people leaving institutions and going into law firms and so forth. But that's a different subject. That's the ethics of the institutions. Now I'm talking about what to do in arbitral clauses. To speak of the, I was chastised for not having referred to the accumulated wisdom of the centuries. Well, the accumulated wisdom of the centuries for a long time was that the world was flat. We've sort of moved beyond that in thinking about things. But more seriously, the world is a different place. The world became a different place after World War II. The number of independent states in the world almost doubled in a generation. International started to mean something else. So quite often in international commerce, which no longer is commerce among various outposts of the world encompassing British Empire, is actually coming from different polities. And as a result, the challenge of neutral adjudication is much greater. And so one needs to take care of this particular issue. All I can say, as an advocate, if I, as sometimes happen, and the greater the disputes, the greater the danger. So as sometimes happens, I represent a client who's a claimant, and the respondent, as I said before, will do anything to defeat the claim, anything by hook or by crook. Even consider that my client, they talk themselves into, my client is a horrible person and shouldn't be allowed to do anything, and should be defeated, therefore, by all means, even crooked means. That includes the appointment of an arbitrator who would be militant, who will do everything. And I've gone through the litany, resigning in just the right moment to sabotage an arbitration which is going on for a year. And appoint another one who resigns again. And I've had that once 5 times. In those circumstances, I pray, next time, let me find a clause which actually doesn't allow that from happening. Of course, the ideal solution is that all arbitrators are agreed by both sides. Of course, that's the ideal solution. But we don't live in an ideal world. In most cases, that doesn't happen, and you need the institution to be involved, and the parties will sort of strategize, making assumptions about what the institutions will do. And most of the time, they will want to appoint an arbitrator who they think fits the case unilaterally. I have nothing against it. I am worried about the other cases which cast international arbitration in disrepute in the difficult and nasty cases.
Perfect. So thank you very, very much. So our judges, now can we have the poll again? We're getting the same question. And so we want to know if 88% has moved up to 98%, or if 12% is really notched up a little bit. Okay. Abayomi, please, can we have the poll again? Is this the, this is the old one, the new one, the second poll. I was going to say, clearly, we must have made an impact somewhere.
That would be very funny if we didn't affect anything.
Exactly. Please, can you vote now, please? Thank you. Abayomi, are we ready?
People are still voting.
Oh, okay.
They're trying to vote for number 3. As I do.
We could have a new debate if you don't like this one.
Abayomi, ready?
Almost there.
Oh, okay. People seem to be thinking again about all your submissions. So then, are we done?
Okay, we can publish it now.
Thank you. 66%, Gary, and 34%. That's a huge leap. I must say that we have to congratulate our Titans, and we have to congratulate Ian for changing the question and getting people to agree with his change of the question, which if that was an exam question, then that's non-submission, that's a 0. But you can't give a professor a 0. So thank you so much.
You can't say I didn't confess to cheating.
Yes, but at least you told us ahead of time. Hello, Daddy said he was going to cheat and then he did. Anyway, so the good thing is I want to say a huge thank you to Jan and to Gary, and to say that we had over 1,000 people registered to attend this webinar. So they didn't register because they wanted to come and see Emilia. No, they registered because they wanted to hear our two titans. They wanted to hear Gary and they wanted to hear Jan share their thoughts and their views on the question and to see them in action. So a huge thank you to Gary, a huge thank you to Jan. I'm going to-
A huge thank you to you, Emilia. I think
thank you.
You as well.
Thank you. I'm going to invite Madeline to say, give us a vote of thanks.
Thank you so much, Dr. Emilia. Distinguished Titans, Professor Gary Bourne, Professor Jan Paulsson. I'm glad to be giving this, this vote of thanks, I would say. It's been an amazing evening. What a way to spend a Tuesday, October evening with such huge titans. Really, on behalf of my colleagues of the 2021 cohort of the Arbitration, Africa Arbitration Academy flagship training program, and all the invited guests in this debate, our profound gratitude to these two professors that have given their time to us to share their positions in respect to the debate topic before us, and indeed for having inaugurated this auspicious event, which marks the beginning of the Battle of the Titans series. The registrations, as you heard from Professor Emilia, flooded in thousands, and attendance were over 1,018. I think it's gone over that number already today. And these large numbers of participants were really flooding in because of your influence and your reputation in the field of arbitration. You will all agree with me that both of our titans have made colossal contributions for the arbitration community, as we heard earlier. And it is no wonder that we have had so many of us reference them in so many ways. So both the titans have fought the battle with razor-sharp arguments, as we've heard, on the motion today, which was party-nominated co-arbitrators, yes or no. And we had the privilege of hearing from Professor Bourne arguing in favor of the motion and tapping into the importance of the practice of party appointments of co-arbitrators. And he made us aware
I think that we've had, as you can imagine, we've had a technical thing that has to happen. Otherwise, you're not on Zoom or one of those. But anyway, I'm going to finish off for Madeline to say a huge thank you. So thank you so very much. And we look forward to having you participate in our debate next year. So bye-bye, everybody. Thank you.
Thanks so much.
Bye, thank you. Bye.